Good morning, everyone. We're just letting everyone come in the virtual door of this event, which we're very used to doing these days. So welcome to our webinar about Massachusetts Parentage Reform. And I'm just going to give it a couple seconds to let people come in, and then we're going to start. We're very mindful of people's busy schedules, so we want to get right to it. So just while we're doing that, I will just share that we do welcome your comments in the chat box that's at the bottom of your screen. And we also welcome your questions in the Q&A box that's also at the bottom of your screen. So we hopefully will have time at the end to answer some of your questions live. And then any that we can't get to, we should be able to answer in other ways. So again, thank you so much for being with us. My name is Kate Weldon LeBlanc, and I am very privileged to be the executive director of a nonprofit called Resolve New England, which helps anyone in New England that is struggling to grow their families through support, education, and advocacy. And today I'm here as your moderator because I am also very proud to be a member of the Massachusetts Parentage Coalition. And we're really happy that you're joining us for this overview of parentage. So I am joined by some incredibly passionate and knowledgeable panelists today, and I'm going to invite each of them to introduce themselves so that you don't hear too much from me. So Representative Kay Khan, would you kindly go first, please?
Thank you, Kate. And I feel privileged to be here. And I'm delighted to introduce myself. I'm Representative Kay Khan. I'm a state representative from the 11th Middlesex District, which is Newton. And I have had the honor of being the House Chair of the Committee on Children, Families, and Persons with Disabilities for many years. And this legislation is very important to me. And I would just like to say that I think that this issue is really all about protecting children, regardless of how they were born or what their family structure looks like. Science and the reality of families in our state have outpaced our statutes. So it's really important for us to consider this piece of legislation. Those children in Massachusetts who do not have a clear legal relationship to their parent or parents are left vulnerable. Imagine not being able to pick up your child from a childcare center or not being able to be with them in an emergency situation in the emergency room. Imagine being at the hospital when your child is born and having to worry that the baby, that if something happens to your partner, that you're not able to take your baby home. These are not hypotheticals. These are actual things happening here in Massachusetts to Massachusetts families. And we know there are attacks on LGBTQ parents and their children happening all over the country. People are feeling rightfully nervous about the security of their families, so we need to fill the gaps and protect all children. And we need to get this legislation done this session. I think also I just want to mention, which I always like to say, it's important that you know who represents you. So if you don't know who represents you, please go online. You just have to type in who represents me, and it will pop up with your state senator and your state representative. And then I would like you to make sure that you call or email your state representatives and let them know that this bill is very important to you and that you would like them to sign on as a co-sponsor of the legislation. This bill, the filing deadline for this session is February 19th, so that's next week. And this bill has not been filed yet, but it will be. And it will have a docket number. And the folks who are working on this will send it out to you. So you will all get, anybody on the call today and anyone you know who would be interested should find out the docket number. So again, I just want to leave you with, please get to know who your representatives are and really contact them. As a legislator myself, I love to hear from my constituents. I love to be in contact with them to know what's important to them. So I would encourage all of you to do that. This is a bipartisan piece of legislation, and I just want to turn it over to Senator Tarr. I'm delighted to be able to work with him and look forward to getting this done this session. So thank you all for inviting me to be here this morning.
Thank you, Representative. So thank you for everything that you said. It's music to my ears when I hear legislators talk about how much they love to hear from their constituents, because I know it's true, but when I tell people that, they don't really believe me. So I love to hear you say that. So Senator Tarr actually wasn't able to join us in person today. As Rep. Khan said, we're so proud that this is a bipartisan bill. Senator Bruce Tarr is our lead sponsor on the Senate side. And we have wonderful co-sponsors from last year as well that we will be working on securing for this year. But the Senate is in session today, so he wasn't able to join us right now, but he strongly supports this bill. And I share your appreciation to him for being part of this. So thank you so much for those remarks, Rep. Khan. Polly, will you introduce yourself briefly?
Absolutely. My name is Polly Crozier. My pronouns are she, her, hers. I'm an attorney at GLBTQ Legal Advocates and Defenders, where I do a considerable amount of work on parentage reform. I've worked in collaboration in Vermont, New Hampshire, and Rhode Island, and currently in Connecticut and Massachusetts. Before working at GLAAD, I actually was a family law practitioner in Massachusetts, as well as a clerk to the justices of the Probate and Family Court in Massachusetts. I'm also a non-biological LGBTQ parent myself. So many connections to this work, and really pleased to be here today. Thanks.
Thanks.
So I'm Doug NeJaime. I'm on the law school where I teach in the areas of family law and constitutional law. And my research and writing is primarily on the legal recognition of non-biological parent-child relationships. And I also have a secondary appointment at the Yale Child Study Center at the Yale Medical School, in which we research and write about the importance of attachments, secure attachments for children to their parents, regardless of the biological connection between them. And I'm working with Polly and GLAAD and Kate as well in Connecticut to pass comprehensive parentage reform in Connecticut, and we hope to be joining Massachusetts.
Jay.
Hi, everyone. I would first like to say thank you for inviting me to speak today. My name is Shia. I'm here to talk about my avenue on becoming a de facto parent and the struggles of that route towards being a non-biological LGBTQ parent. That I've been jumping through hurdles and hoops for the past 10 years. I started the process on parenting my child and attempting for it to become legal when I was 19. I'm now 30, so for over a decade, dealing with the Massachusetts legal system, and now finally becoming a guardian of my son, and the experience that I had, and how my interaction with the state has been. I'm born and raised in Boston. I'm a single parent business owner, and I'm here to speak about the route that I had to go through and how it still affects my daily life on being a parent, and the struggles that I have with just being a de facto parent, and how I hope that in the future there's change for us to have better representation. So thank you for inviting me to speak today.
Thank you for being with us.
Thank you. So, and I'm Dean Hutchison. I'm been in this field for 17 years. I've worked at Circle Surrogacy, which is a Boston-based surrogate and parenting agency. I'm a lawyer at the Weltman Law Group, and I've been either the vice chair or the current chair of the American Bar Association's Assisted Reproductive Technology Law Committee. I think I got it all in there, which is about 500 lawyers worldwide that kind of focus on this area of law. And we get involved in both domestic legislation, we do conferences, we get involved in international symposiums as well. So I'm going to talk, when it's my turn, just really about how this statute helps and fixes our missing links to the law on gestational surrogacy and assisted reproductive technology.
Thank you. Thank you all so much. So I wanted to just start by giving a very brief just overview of what we mean when we say parentage, because I know for me now I've been doing this wonderful collaborative advocacy work throughout New England, but I know before I started doing that, I was not familiar with the term parentage, and I imagine that many of you listening right now are not as well. So when we say parentage, we mean the legal parent-child relationship. And again, many of you may not be familiar with that term because I think many of us take parentage for granted, honestly, myself included, because your parentage in many cases is assumed. But for many families, that is not the case. And that is part of why we are working so hard on changing these laws throughout the country and the region. So again, our organization and all of us on the call, we celebrate the fact that there are many different families and many ways to build families. And so what we're really looking to have is a Massachusetts law that reflects that diversity of families that exist in Massachusetts. There are many paths to parenthood. And so we want there to be paths to parentage that reflect all those different paths. Myself, we built our family through IVF, but as a heterosexual couple, our parentage was assumed right off the bat in the hospital room without any further explanation needed. So just I'm very mindful of how unfortunately that is not the case for so many other families. So without this, it leaves many of our children in Massachusetts vulnerable and adds, as Jay just briefly mentioned, adds a lot of stress for parents and caregivers as well that are not secure in those rights. So as I said, please put your comments in the chat, your questions in the Q&A box. Our whole purpose in doing this today was to really help you understand something that can seem pretty complicated, but I would say at the core of it, it's something pretty fundamental and significant, which is the children and parents and making sure they're all protected. So RepCon, I just want to start with you. I want to just thank you again so much for your leadership on this bill last session. The bill had good progress, had a great hearing, and was reported favorably out of children, youth, and persons with disabilities, but wasn't able to get across the finish line last session. But we wanted to start by really saying thank you to you again for your leadership. And I guess you kind of spoke to this already, but do you have, specific suggestions in terms of what advocates can do that want to support this bill?
Yes, again, I think that one of the most important pieces is to reach out to your own legislator and let them know how important this is to you, and to even share your stories. If you have stories that you would like to share, either for stories about yourself or friends of yours that you know about, I think legislators are always taken in by the stories that people relate to them. And every bill in Massachusetts does get a public hearing. And so at some point there will be a public hearing for this legislation. Again, we don't know exactly what committee it will be assigned to. So that's all will be worked out after the bills get filed and the closing date of February 19th takes place. And so it would be important, I think, for folks to come together and think about how they might like to participate in the public hearing. I think the public hearing, again, and I think sharing your personal stories, I think really resonate with legislators. So I would say that that they should be working with you all to figure out who is going to come and speak and make sure that happens. So again, the stories are important, and there's a wide range of reasons why we need to be thinking about this, and it's good to know that it's also going on across the country. So this is a good time, I think, to be thinking about all of this. I think we have supportive folks out there, both in the legislature and beyond. And I would just, again, just encourage people to participate in the process and learn about the process. It's an interesting process, and every voice counts. So that would be what I would have to say at this point.
Great, thank you. So Polly, let me turn to you. Could you explain kind of I know it's a comprehensive bill, but could you explain just kind of a brief overview of the Massachusetts Parentage Act and how it is based on the Uniform Parentage Act of 2017? Oh, You're muted, I think. Oh,
It wouldn't be a webinar
it
without
wouldn't
someone on mute,
exactly.
right?
You win the
Um,
prize. You win the
Yes,
prize.
excellent. Okay. So the Parentage Act is, I think a really critical bill. It codifies SJC precedent. It really updates extremely outdated statutes and ensures that every child has equal access to the security of legal parentage. It's based, as you said, Kate, on the 2017 Uniform Parentage Act. And that is a model act crafted by national experts in a bipartisan manner, informed by experts in child support, medical ethics, parentage law. It's a model act that's recommended to the states to say, make sure your parentage laws are updated to reflect modern science, to reflect updates in constitutional law, particularly here, marriage equality, right? The Obergefell case in 2015, which ensured marriage equality throughout the country. As we know, Massachusetts led the way much earlier than that with the Goodrich case. To ensure that today's parentage laws reflect the full diversity of our families. So that's the goal of the UPA 2017. That's the structure for the bill. And then we updated it and didn't update it. We made sure it was adapted to Massachusetts, right? That it reflected those SJC precedents that have done really good work to protect LGBTQ families in particular. Rather than replacing Chapter 209C, we update it to make sure, that's our paternity law, that it addresses parentage, that it's gender neutral and inclusive of all families. And then it makes sure that we're adding protections from the UPA for children born through assisted reproduction and children born through surrogacy. So effectively, the bill is structured on the UPA, this national bill, to make sure that Massachusetts law is truly best practice and constitutional, which right at this point, our statutes are over 30 years old. It's time for an update.
Right. So again, I know it's a comprehensive bill, but can you speak to what kind of some of the core elements are of what the MPA does?
Absolutely. Fundamentally, it really clearly outlines, here are the paths to parentage, right? And those paths are birth, adoption, acknowledgement, adjudication, genetics, presumptions, including the marital presumption, assisted reproduction, de facto parentage, and surrogacy. So it outlines all of those paths to parentage and then provides courts with clear standards on how to establish parentage under each of those paths. I particularly like the fact that it codifies access to voluntary acknowledgements of parentage, which essentially ensures that LGBTQ families can have the same access to securing their parentage at birth as other families. It also provides, for the first time in Massachusetts law, kind of clear statutes protecting everybody involved in the surrogacy process, marital status neutral protections for children born through assisted reproduction, and guidance for our courts on how to resolve competing claims to parentage. So in that way, I think it's a really important bill that just, provides clarity and better access to justice and more consistency in our courts.
That's great. Thank you. So Professor NeJaime, Polly mentioned de facto parentage as one of the paths to parentage that are covered under the Mass Parentage Act and other parentage laws like it. I'm not sure most people, like I said, don't know if everyone's even heard of parentage. I think others haven't heard of de facto parentage. Could you kind of explain for our audience a little bit about what that status is about?
Yes. So a de facto parent is an individual who's functioning as a child's parent, even though she's not the child's biological parent. And my colleagues at the Yale Child Study Center often refer to this individual as the child's psychological parent. This describes the individual who is the parent from the child's perspective. And as we know intuitively and from decades of research on child development, the psychological parent-child bond doesn't depend on a biological connection. A child's secure attachment to their psychological parents is key to development, and the loss of that relationship causes significant trauma. And so part of what de facto parentage is intending to do is to ensure that every child receives the security and the benefits of a parent-child relationship, not just children being raised by biological parents.
That's
de facto parents are parents in ways that reflect our understanding of what makes a parent. So one thing I just want to emphasize is the difference between a de facto parent and a non-parent or a third party. The person who's a de facto parent is actually functioning as the child's parent on a day-to-day basis and over the course of a long period of time. An individual doesn't unilaterally become a de facto parent. An existing legal parent fosters that parent-child relationship. And most importantly, a de facto parent is not a third party. So a relative who contributes to the care of the child is not a de facto parent. A paid childcare provider or a nanny is not a de facto parent. A cohabiting boyfriend or girlfriend who provides some care is not a de facto parent. All of these individuals are non-parents or third parties. Relatives, including aunts and uncles and grandparents, may play a very important role in a child's life, but they're not the child's parents. They don't hold the child out as their child ordinarily. And the child doesn't consider them to be their parents ordinarily. So it's only if the individual develops a parental relationship with the child that the individual is a de facto parent.
Great.
I can talk a bit about current law and what the Massachusetts Parentage Act changes.
That would be great. Yeah, I actually was curious. I know, like, I hope everyone heard your whole introduction, but I know you are really a national expert. We're fortunate to have you in New England, but you're really a national expert on this. So I wondered if you could kind of put de facto parentage and parentage reform in general kind of in the national context for us a little bit.
Let me start by just saying that Massachusetts was a leader in this area, and there's currently de facto parent status in Massachusetts. It's an equitable status that was created by case law. So the SJC's decision in ENO in 1999 initiated this. But right now, it's confusing, and subsequent decisions have made it relatively murky. And this is true for children and parents, but also for attorneys and judges. And so part of what the statute would do is clarify de facto parent status and reduce litigation. In its current form, de facto parentage in Massachusetts is an unequal status. It provides access to visitation, but not full parental status, nor does it impose an obligation to support the child financially. And it is litigation. So having a statutory provision would establish clear standards so that someone can easily clarify that they're a de facto parent, and then have all of the legal rights and the legalities come that. The Parentage Act, which common ground with other statutes I'll mention in a minute, a very rigorous standard for establishing de facto parentage. So under the Massachusetts bill, a person seeking to be adjudicated a de facto parent has to satisfy 7 requirements, and they have to do so by clear and convincing evidence, a heightened evidentiary standard. So the person has to show first that she resided with the child as a regular member of the child's household for a significant period of time. Second, that she engaged in consistent caretaking of the child. Third, that she undertook full and permanent responsibilities for the child without expectation of financial compensation. Fourth, that she held the child out as her child. Fifth, that she established a bonded and dependent relationship with the child, which is parental in nature. She also has to show that an existing parent of the child fostered or supported that bonded and dependent relationship. And finally, seventh, she has to show that continuing the relationship with the child is in the best interest of the child. So a person has to satisfy each and every one of these requirements by clear and convincing evidence in order to be adjudicated a de facto parent. I want to point out on this parent-child relationship, and as I said, a de facto parent is not a third party non-parent. You will hear some folks raise constitutional concerns with de facto parentage, but I just want to emphasize that practically all courts that have considered this question have overwhelmingly concluded that de facto parentage is constitutional. And this is reflected as well in recent legislative enactments and in the clear scholarly consensus. Constitutional concerns about de facto parentage generally invoke the US Supreme Court's 2000 decision in Troxel versus Granville, which was a case involving a petition by grandparents seeking expanded visitation with their grandchildren after their son's suicide, the father of the children. And the grandparents were relying on the third visitation statute in Washington state, which at the time allowed any person the ability to seek visitation with a child, quote, at any time, based simply on the best interests of the. That's very different than what we're talking about here. The court in that case didn't produce a majority opinion. In fact, the court fractured into 6 separate opinions among the 9 justices. And Justice O'Connor wrote the plurality opinion that struck down the statute as applied in the specific case before it. Justice Kennedy, who many of you know represented the court's swing justice for many years before he retired in 2018, used his opinion as an opportunity to clarify this distinction between de facto parents and true third parties. He said, quote, a fit parent's right vis-a-vis a complete stranger is one thing. Her right vis-a-vis another parent or a de facto parent is another. And since then, practically every court to consider this has concluded that Troxel doesn't preclude states from protecting de facto parent-child relationships. This includes Massachusetts. So Massachusetts, again, has been a model here. In 1999, in E&O, the SJC concluded that the de facto parent status doesn't intrude on the liberty interest of a legal parent. And the court explained, quote, the family that must be accorded respect in this case is the family formed by the plaintiff, the defendant, and the child. The de facto parents, biological parents' parental rights do not extend to the extinguishment of the child's relationship with the de facto parent. So the key distinction here again is between claims by third parties and claims by those who have functioned as parents. Legal parents have the constitutional authority to exclude non-parents. They don't have the constitutional authority to exclude other parents. And the Constitution leaves to states the ability to define parentage to include de facto parent status. Just returning to your original point, Kate, many states are now recognizing parental rights and responsibilities for people who are de facto. And this is actually, interestingly, cutting across political, ideological, geographic. You see states like New Jersey and Hawaii and Washington, but also states like Oklahoma and Kansas adopting these de facto parent statuses. The trend is clearly in favor of protecting these relationships. And going back to something that Polly said, marriage equality decisions have only accelerated parentage reform, specifically with respect to de facto parent status as well. Obergefell versus Hodges, the US Supreme Court's marriage equality decision, really recognized constitutionally the equal status of same-sex couples and their children. And that means also the equal status of non-biological parent-child relationships, given that same-sex couples raising children necessarily include a non-genetic parent. Justice Kennedy made this clear in Obergefell. The court confirmed this reasoning 2 years later in Pavon versus Smith. I've long argued, and many courts now acknowledge, that the Constitution does not merely permit, but in fact requires the legal recognition of parent-child relationships, regardless of biological connection. And so we've seen, since Obergefell especially, a real concerted effort across the country following the Uniform Law Commission, state legislatures and state courts engaging in parentage reform. And the most important aspect of this has been to have the law recognize the many ways that people form families. This includes same-sex couples forming families, and includes non-biological parent-child relationships. And so several states, Washington, California, Maine, Vermont, Rhode Island, have enacted their own version of the Uniform Parentage Act that includes comprehensive statutory protections for de facto parents. States like New Hampshire and New York have also comprehensively updated their parentage laws in recent years to protect non-biological parent-child bonds. And in our region, unfortunately, Massachusetts and Connecticut have fallen behind now. And fortunately, the legislatures in both states are considering parentage bills this session that will update these outdated laws and protect de facto parent-child relationships.
Thank you. Yeah. So we're kind of in a race, Massachusetts and Connecticut. Neither of us want to be last. We need to get this done. The rest of New England has done this work. So thank you. Thank you so much. So Jay, I'm so glad to turn to you now. I mean, obviously you did not need that kind of scholarly explanation of what de facto parentage is because you know it all too well personally. Could you share a little more about your family's story? We definitely want to hear about your son and your long journey to secure your parentage.
Absolutely. Well, I'll start with saying, hearing all that and hearing that there's effort to put people who have gone through years and years and years of trying to prove that they're a parent, if there's an avenue to having more than just a sticker of a glorified babysitter, it makes me feel very, very good. So thank you all again. I will give kind of a brief and quick rundown of how I wound up here. So when I was 19 years old, I was dating a woman who wound up getting pregnant and was there the day that the child was born, actually named the child, myself in the hospital with this newborn baby, 1 day old, 1 moment old. So was there with this woman who has this child, and very soon after the baby was born, it was clear that she wasn't going to be fit to be raising a kid for issues that are her thing. Me as a 19-year-old decided that I was going to take on raising this kid, non-biological, not related to the woman in a romantic sense anymore, but basically left with this child, a full-time college student, bring the baby to school. And child services were involved in one sense, but wouldn't necessarily help me go about becoming a foster parent because I was still sort of just like an ex who was a glorified babysitter. And years of this continued, years of me raising someone else's kid, to the point where I started knocking on the door of child services saying, hey, what's up with adoption? Or could I foster? And completely getting pushed out of the door every time, just with nowhere to go. To fast forward, child services started realizing that I'm raising someone else's kid, yet the biological mother is benefiting from the services from the state. And so they demanded that the child goes back to her, someone who he wasn't around, someone who he hardly knew anymore. And so the child goes back to the biological mother after having many years of not being with her. For him, which was so psychologically jarring. And for me, having this kid ripped from me with no one to have my back for this help. Goes back to the biological mother and winds up in the foster system due to some misfortunate events. Now this child who I've raised is now in the foster system, and I'm knocking on the door saying, I raised this kid. His name is my name. I raised this kid. I want my son back. Let me foster. And being rejected to foster, being rejected to adopt. Constantly jumping through these hoops, banging on doors and being pushed away every single day. Okay. Now, a circumstance happened in the foster home where he winds up having to leave and goes back to the biological mother, the person who he still had hardly any relationship with, which drove me to the point of reaching out to a lawyer, Joyce Kaufman, who I give many thanks to, who suggested de facto parenting, which for me is a foreign avenue, where I had to prove that I was a parent from day one. From photographs of every single day to documentation, to psychological evaluations, to all of these protocols for me to then years later finally become a de facto parent, which still has me sitting here stripped of being a real parent. I don't have parental rights. I still have to walk around with his guardianship form in my wallet. I still have a nightmare when it comes to getting his healthcare set up. It's taxes, this whole nine, where I spent 8 years trying to prove that I was a de facto parent, finally being granted to be a de facto parent, yet sit here scratching my head at the fact that I am still not legally considered his mother. I'm a glorified guardian. And having always in the back of my mind the worry of the biological parent petitioning also, where I went through all the hoops, I did all the steps, I did the court, I did all of this work, yet still have to walk around with a guardianship form in my pocket because there's this uncertainty of my parent status being petitioned by the biological parent. And so although there's a good ending to the fact that my son is in the other room on his class right now, an 11-year-old, gorgeous kid, smart kid who has been my life, it still sometimes breaks my heart, the fact that if I need to leave the country with him, I have to tell the court. If I get a call from the bio mom who's up in arms about something, I have in the back of my head that there's a chance that she could petition. And so it makes me wonder, and it makes me hope that people in the LGBTQ community, single parents, people who have truly proven that they have parented a child since the day they were born, can walk away from all the effort and from the years of raising a child where the biological relation is not the true bond, where I hope that there's a point where they could walk away where they feel like they're a parent and no one's questioning it anymore. And you know, from everything of my inability to adopt, of my inability to travel with him without having to notify the state, it breaks my heart. But you know, there is kind of a air of hope. You know, for example, here in this webinar, where there's all these people attempting to make some change. But since I was 19, as a single parent, as a business owner, now as a 30-year-old with an 11-year-old, I hope that all the effort in lawyers and bills and this and that could result in the dust settling and being recognized as a parent.
That's great. Well, thank you so much for sharing your story. I know it's hard to talk about all those difficult steps that you had to take to secure what you have already, but it really illustrates exactly what we are trying to achieve with this bill. And I just have to say that I am so sorry that you had to go through that much, but I also want to applaud your perseverance and your determination to protect your son and to secure your own rights. And I just really empathize and can only imagine all the stress that caused. But I'm happy you guys are where you are now. But we want so much more, and for the others that will go behind you to make the path smoother for them as well.
I appreciate it.
So thank you.
Thank you all.
Yeah, we'll come back to you, I bet, with some questions. So Dean, I want to turn to you now. I think, you know, rightfully so, Massachusetts, I think, has long been considered a leader on assisted reproductive technology and coverage for family building like IVF, and we're proud of that. So then I think people are really surprised when I or anyone tells them that right now Massachusetts only has one sentence, I think, in the entire parentage law that reference assisted reproductive technology and nothing about surrogacy. So can you speak to this a little bit, and can you maybe explain again for those that may not know, could you explain a little bit of what surrogacy is?
Yep, I'd be happy to. And thank you, Jay, again for your story. I feel like I'm going to be a letdown to everyone after that amazing emotional story that I'm just going to bore you with my talk. But so like you're saying, surrogacy and assisted reproductive technology, Massachusetts is a leader in every element of it except for the law. And we were a leader in the law for a long time. We actually had very good case law that came 20 plus years ago, and then everyone around us has since codified it and made it easier and simpler. And we sit and watch and say, well, we have a case, so we're fine. But that's not the case. So from a very general background, what surrogacy is basically intended parent or parents contract with someone to carry their child. And that child is either going to be a makeup of both their genetics, a sperm and egg, or a sperm donor and an egg donor, or you know, one or the other. And that woman carries the child for them. They have a contract. They've been you know, had legal representation, have gone through counseling, have talked to doctors. And then at the end, when she delivers the child, that baby goes to the intended parents, and there's been a court proceeding most of the time prior to that birth establishing their rights. So it's this wonderful process. And in Massachusetts, we've had case law on that subject for over 20 years. We have in our case, we have the Culloden decision and the Hodis decision, which are the big ones. But the problem being with those cases is they are 20 plus years old. They don't really impact all the different types of parents that can do surrogacy. And for, as a fact, for many years, because that case was a heterosexual couple that were married, when you went to get a pre-birth order for a same-sex couple that couldn't get married, or a single individual, the courts and/or Department of Vital Statistics would say, sorry, we can't accept this order because it doesn't fall under the facts of the Culloden decision. You have to do an adoption. You have to do something post-birth, and you don't get those parentage protections till well after birth.
Yeah. So without those, what has been your experience, both as an attorney, but also getting to know these families so well? What is the impact of the lack of these clear statutes on the process and on them?
Yeah, I mean, from my point of view, because I work at a surrogacy agency and we have deliveries all around the country in different states, you can just see the difference in that. When you're in a state that has a codified system in place, that you know exactly what the judges expect, you know exactly basically a similar timeline that the decision is going to come down to, it's a lot less stressful. So the simplest part of this process should be the legal part, because in 99.9% of the cases, all the parties are in consent. They're just simply filing it with the court to give them notice that this is what we want and this is what we expect. And in many states, we get same-day decisions. We get decisions within 2 weeks, and those parents by week 27 to 30 of the pregnancy have fully established their rights, and now are just waiting for that, the happiness and I shouldn't say the easy part. They actually don't realize it's much harder once they get after birth. But
yeah, parenting is not the easy part, but
yes,
yeah.
We don't tell them that, though. We want to
Right.
make sure they get there. But it's just that, so in all these other states, it's a pretty simple process. And particularly, I think Kathy DeLay, who's wonderful, who's a member of our coalition, who practices in Vermont and in Maine and New Hampshire, will just tell you that in those states, it's a simple forms, it's filed with the court, she gets an easy answer in a couple of weeks, and it's done. In Massachusetts, not only do we differ county to county on what's expected and what vital statistics may accept, we really differ judge to judge. We can go into Middlesex or Suffolk, and if we get Judge A, we know, oh, this will be pretty quick. Don't worry, clients, we'll get you an answer. And then we can get Judge B, and we'll get a return date 6 months after the due date for the actual hearing. So we need more consistency. We need more clarity so that these parents don't, feel that added stress to what's already going on in their life, and they know their parentage rights are secure before rights. And what it really does is goes all the way back to what Representative Khan was saying earlier, is in the end, the most important part of this process is the child or the children to be born. And it gives those children, even though they don't know it because they're in utero, and even though they won't know it for many years, but it gives them this added protection that their true parents are known from the instant they're born, and they are the ones in the hospital making those decisions. They are the ones that are taking the child home, and they are the ones that have fully vested rights from moment of birth.
Right. Yeah. I mean, I think, like I said, before I started doing this advocacy work, parentage was a new term to me. And I think even when I first started learning about it, I certainly believed that change was needed, but it didn't really resonate deeply in my heart until I started hearing stories like Jay's and others in the different states that we're working in. As Rep. Khan said, these aren't theoretical things. We've had people who the non-biological second mom is literally worried about the health and well-being and life of their partner, the birthing partner, and their baby, and at the same time they're worried that they have no legal protection and rights to their own family that they were part of building from the beginning and had every intention of co-parenting. So once I started getting to know these people, I was like, we can't let this continue. We need clarity and consistency.
Yeah, and what the law does as well is it protects the donors and the carriers, gestational carriers, the surrogates, because I'll just give an example, and it's a case that's pretty recent, and actually in the dicta of that case, they kind of told the legislature, hey, you should act on this, and that's the adoption of Daphne, where an intended parent, a single father, was having a child through surrogacy. For his specific country needs, he needed that gestational carrier to at least be on an initial birth certificate, just so he could register the birth certificate at home and it didn't flag any issues. And then because our case law regards pre-birth orders and doesn't mention anything about a post-birth order, the courts have always taken the position, and the same with Department of Vital Statistics, that if you don't get the pre-birth order before the birth, even if it's none of your fault and there was an early birth happened, you then have to shift to the adoption statute, and you're no longer protected under that case. You're now in a whole different realm of law. So in this case, they filed the adoption immediately after birth, a single parent adoption. It got pushed back by the court because of a form issue. The father then went home to his home country. They filed again, and they said there was no jurisdiction because he left the state and they couldn't do the adoption. After years of appeals, 2 years later, they finally said, well, because the birth mother's still in the birth certificate, the child has a residence here in a sense to file that adoption. But it took 2 years to not only fully secure the parent's rights, to fully secure the child's rights to his sole parent, but really to protect the gestational carrier as well, because she's listed as a parent. And there's the potential of cases coming after her because she's a listed parent. She may be up for child support, things like that. So this law really will help to protect every single actor in these cases. As you were mentioning, the only statute we have on the books is an insemination statute that talks about married couples and that they're the parents of a child born with the consent of insemination. We need a lot more than that.
Yes, yeah.
Very much so. And we don't, like as you've said and other people have said, we don't want to be the last one in New England. It might be that way, and I'll take it if we are the last one, but it would be nice to maybe beat Connecticut. Get it done first.
Yeah, absolutely. A good-natured rivalry there between New England. Thank you.
Yep.
So I definitely want to get to some of the questions in the chat. And just to kick us off, I mean, I feel like we'd be remiss if we didn't reference, probably for all of us, what's at really the forefront of all of our hearts and minds right now is the pandemic and COVID-19. And I mean, I'll open this up to any of you that want to jump in, but how has COVID-19 kind of changed your view on this work that we were already doing in terms of advocating for parentage reform? Polly, do you want to speak to that? Because I know you and I have been working together in a lot of
Yeah,
states.
absolutely. I mean, it immediately comes to mind how much COVID-19, I think, has just increased families' anxiety, right? That when you're, it really highlights the need to make sure your children are protected no matter what. And I think about how, we passed the Parentage Act in Rhode Island in the midst of COVID-19. I think it was the only bill that was passed last session because of that fear. And because, in fact, many of our parents in our coalition were first responders, ICU
Right.
doctors, nurses, and whatnot. And they felt so strongly that, in fact, when they can't protect their own children, when they're worried about being able to make medical decisions for their own children, when they're worried about what happens if one of them passes away and they don't have that security in that other parent, it really becomes real in a whole new way. And just it became an imperative to pass the legislation. So I think that it's just a reminder of how important these core relationships are to us and how we need to make sure that every child has access to those protections equally and in a way that's efficient. And it's just an imperative. I don't know if anyone wants to add to that.
I don't mind jumping in.
Sure.
I would just say, first of all, I want to thank Jay for her story. It was really an amazing story. And I guess I was thinking all along while you were speaking that just all of the contacts that you have to make constantly is not easy, certainly under the situation that we're in with the pandemic. And I know also that the courts, have been open and closed and open and closed, and it hasn't been easy, I think, just to make those contacts with the court to deal with whatever you need to deal with, either with yourself or with your lawyer. So I just think it's been, very difficult. And then the anxiety of it all, I think, as Polly mentioned, just the anxiety. I mean, I can hear that in your voice, Jay, as you spoke, just the anxiety of not knowing what if something happens to me, what happens to my son. And so there's just so many things that I think come to the forefront because of the pandemic. So, and again, I just want to thank you for sharing your amazing story.
Yeah, agreed for sure. But I guess one thing that I was struck with in your story, Jay, was just that you really had to, I mean, as Doug again indicated, like more from a scholarly perspective, but from your personal experience, you had to meet a really high standard to be deemed a de facto parent. And I know, you're struggling with the kind of holes that still exist in securing that status, but it was better than what you had before. But it sounds like you had to go through a pretty high standard to kind of prove that status, even though you really had been there literally since day one. Can you speak to that a little bit more?
Yeah. The amount of documentation I had to collect um, was wild and stressful, and collecting photos and documentation of doctor's appointments. It was dreadful, and it felt almost over the top, as if no one would take my word that I was there since the day this child was born. Before I get too into that, on the note of COVID-19, although I wasn't having to jump through all these hoops, luckily for my de facto parent avenue during COVID, when I was jumping through these hoops, I was quite literally knocking on the door of DCF every day, or going to court with Ms. Kaufman, once or twice a week. And so if there's someone out there that's, attempting to become a de facto parent or prove it, where they're worried that the safety of their child is in jeopardy because there's a chance of them being thrown into a foster system or being sent back with a biological parent who isn't fit or who isn't safe, trying to juggle that during a pandemic where courts are closed, where people aren't answering their phones, I can only imagine the amount of stress that these single parents are going through, where they're worried about the safety of their kid because everything is delayed. And so I was lucky that when I was granted guardianship, it wasn't during a point where you couldn't knock on someone's door. I was literally, the DCF office is about 10 blocks from here. I would wait outside. Actually, the first time I saw my son, when he was in the middle of a foster care visit after he was taken, was in the DCF parking lot because I was going there every day. And so for COVID, for other people attempting to become a parent, I hope that the Parentage Act can kind of surpass the issues of COVID where everything is closed. And so,
Right.
yeah.
Thank you. Thank you. So I do want to take the couple questions that we got from our attendees. Thank you, and feel free to add more if you. We do have a little bit of time to address these. So someone asked, why was the policy decision made to only allow de facto parentage claims to be brought by the person seeking de facto parent status and not by the existing biological or legal parent against the de facto parent, for example, to pursue child support? Does someone want to take that one, Doug or Polly?
I can take it, sure. So it's a great question. So just so we're all on the same page, for other paths to parentage, the person who's seeking to be adjudicated a parent or establish their parentage can do that, and another parent can seek to have the other parent adjudicated a parent. But with de facto parentage, it's only available for the individual claiming to be a de facto parent to establish their parentage. And some states don't do that, but the Uniform Parentage Act made that decision, and working in Connecticut, as well as folks working in Massachusetts, have also followed that. And the main reason is that we want to protect de facto parents who have become the child's psychological parent, but we also don't want to discourage people from stepping up and contributing to care for a child because they fear that the existing parent is going to seek financial support from them. And so this tries to balance those concerns so that people continue to do the work of helping others. But when they're truly have become a parent, that person is able to establish their parentage.
That's helpful. Yeah. Anything you wanted to add, Polly, or anyone? Okay. Yeah, that's great.
I agree. Yeah.
All right. So our next question, can't scroll down for some reason. Sorry, technical difficulties. Um, sorry, again, with regard to de facto parent status, how do you respond to people who have concerns that an abusive partner will use this as a weapon to control the victim of abuse? And I appreciate this question because we have been doing a lot of outreach to our great colleagues in various advocacy communities and other providers, to really listen to some of these concerns, and we really appreciate people advocating, of course, for the populations they most closely serve. So
Yeah,
not
I can hop in on that. Do you
okay,
want to, yeah. So first, and Doug might also as well, but well, first, I think the Uniform Parentage Act drafters were really thoughtful in structuring the status to try to prevent those kind of abuses. There's a standing requirement, right? Not everybody gets through the door. You have to first, you have to first meet the standing requirement. There's also, as Doug said, so many different factors, 7 different factors that you have to prove, which are, really present a high bar. And then there's the catch-all best interest analysis, which really ensures that, that establishing this person as a parent is in the best interest of the child, which really, I think if you look at all the cases that have happened in Massachusetts since ENO, has weeded out people who have perpetrated abuse in some way, and is really a powerful catch-all and allows the court the discretion to make sure that those people aren't getting through that test. And finally, I will say that the clarity of the statute in the bill is it elevates the de facto parent standard in Massachusetts, right? It's a clear and convincing standard, evidentiary standard, instead of a preponderance standard under the current case law. And it adds factors, it adds that standing requirement. It really, in fact, raises the bar for de facto parentage in a way that I think is thoughtful and designed to, make sure that people who are perpetrating abuse aren't making it through to that status. And again, anyway, I guess I'll leave it at that and just see if anybody else has anything they want to add.
I mean, I'll just add also that, both in Connecticut and Massachusetts, we've worked with the DV advocacy community to make sure that we're crafting language to add to the bills that protect survivors and take additional steps from what the UPA did to provide ways for survivors to defeat any type of claim that arises. And so I think it's been a testament to those who have worked with us to be able to draft language of this kind. And the final thing I'll say is that, a state like Massachusetts that already has a de facto parent pathway, Connecticut has a third-party visitation statute. In Massachusetts, this threat already exists to the extent it is one, and it actually comes with rights and no obligations, whereas the de facto parent status under the statute would impose a child support obligation. So I think it's reasonable to conclude that the incentives actually would look different under the de facto parent status in ways that mitigate some of the concerns that are raised.
I really appreciate you mentioning that because, again, I'm a non-attorney on this panel, but the thing that keeps, just as a layperson, the thing that keeps running through my mind is just that this legal status already exists in Massachusetts, and that in some ways I feel, unfortunately, with any aspect of the law, we can't really prevent a fraudulent case being filed that, doesn't have the legal standing to be successful. But I think what we can do is have a clear law like this that prevents a lawsuit like that from being successful. And also, like you said, in some ways, having the obligations and the responsibility of parentage maybe true parents, I think, really want that. They want the protections and they're willing to take the responsibilities that come with that. But I think parents kind of utilizing de facto parent status for a fraudulent reason wouldn't want the responsibilities that come with it too, including financial responsibilities. So, all right. So I don't see any other questions in the Q&A box. Are there any other comments from the panel? We're right at 1 o'clock, which is so great right now. So I think we'll just end there. I want to thank you all so much. As Representative Khan said, this is kind of a pivotal moment for the bill. It's going to be filed next week, and we really welcome and appreciate anyone who will co-sponsor with us this bill, and the many advocacy organizations who have signed on to support it as well. We're very grateful for. We look forward to getting our last session co-sponsors back, and then really working to attract new ones as well. So we look forward to future conversations and future work together. So yeah, and my colleagues at GLAD have been kind enough to be putting great resources in the chat throughout, but there's this wonderful information in at massparentage.com. So thank you all, and we'll hopefully see you virtually or in person one of these days soon. So thank you.